Good afternoon. As you settle on in, I'm going to be introducing the next panel, which is one that is near and dear to my heart. It's the administrative state. And we're very fortunate to have some of the leading lights in the field, Naomi Rao and Michael Fitzpatrick. Now, Naomi, Michael, and I have all had the honor of serving as political appointees in the Office of Information and Regulatory Affairs. That's the office in OMB that regulates the regulators. I served during President Clinton with Michael as my special assistant for a period of time. He also served during the Obama administration, the first few years. And Naomi was nominated, recently confirmed, and is now currently serving as the administrator of OHIRA under President Trump. Now, OHIRA is the office that's tasked by various executive orders to review the drafts of proposed and final rules issued by executive branch agencies, otherwise known as the process of centralized review. Centralized review, in one form or another, dates back to Nixon, Ford, and Carter administrations, although in those days only a handful of proposed rules were selected, and the resulting critiques that were undertaken of an agency's work product were placed in the rulemaking record. President Reagan issued Executive Order 12291 in 1981, which dramatically changed the scope and nature of centralized review. Among other things, all draft, proposed, and final rules from executive branch agencies were submitted to OHIRA before publication for comment in the Federal Register. The review itself and the interchange between the issuing agency and OHIRA was not on the record. The executive order required agencies to undertake cost-benefit analysis for all major rules, and it established certain decisional criteria that all regulatory actions had to satisfy, including that benefits outweigh the costs and the proposal should maximize net social benefits. Now, the basic tenets of the Reagan order have been maintained, albeit with important modifications, including limiting OHIRA review to only significant regulations. There's a standard for that. In other words, selectivity in the review. Emphasizing the expertise of the issuing agency and implementing certain aspects that would promote transparency and accountability. This framework, which was set forth in 12286, signed by President Clinton, has existed through George W. Bush, who added guidance documents to the mix, Obama, who emphasized retrospective review of existing rules, and so far President Trump, who's added a 2-for-1 requirement and a regulatory budget. So with that brief and greatly oversimplified history of over 50 years, let me reflect on the title of our symposium today, Executive Power and Sources of Constraint. And then I would like to ask each of you to talk about how you would explain or justify the legitimacy of presidential review. And I do that against a background, obviously I'm a strong proponent of centralized review. But the argument, which is serious, is that Article 1 of the Constitution, which we heard about this morning, sets forth in loving detail various powers of Congress, and most importantly, it gives Congress, not the president, the power to make laws. that Congress has delegated rulemaking power subject to intelligible principles, that's the words of the Supreme Court, to one or more specific agencies. And that in doing so, the Congress has entrusted the agency head, not the president, to make a decision as he or she best determines would satisfy the statutory standard. So what is the justification for the president or his agent, OHIRA, to get involved in the decision-making process of a rulemaking proceeding? And if centralized review is an example of expanding presidential powers, what, if any, sources of constraint exist? Naomi, we want to start?
Sure. Yeah, thank you, Sally.
Sounded on.
It's on? Okay, great, thanks. Thanks for having me. It's great to be here in a sort of administrator/academic role, so I kind of enjoy that. But to your question about the constraint, I mean, I think, Congress, of course, in many ways imposes the primary constraint on agencies because it establishes the statutes that create the agencies and give them their regulatory power. So there's a real source of constraint about what kind of power Congress wants to give to agencies in the first place. And of course, also, if agencies fail to exercise the power in the way Congress prefers, they can always change that source of authority. So agencies, at the outset, it's important to stress that these agencies have no kind of free-floating regulatory authority that they can exercise without some congressional basis. Yet, on the other hand, once Congress has given that authority to the agencies, and even, I think, specifically to the agency head, that authority has to be exercised within the executive power. And there, of course, the president is the head of the executive branch. The Constitution creates a unitary executive, which I think in many ways makes the president what I like to think of as the administrator-in-chief, right? He sits on top of all of the executive agencies. And I think it's supported by the structure and the text of the Constitution that the president can exercise both control and supervision over what the agencies are doing. And when I say control and supervision, of course, that means within the boundaries of the law. So agencies need to implement presidential priorities within the four corners of the law, but Congress often does leave substantial discretion to the agencies. And when it's done so, I think there's a real question, who should exercise that discretion? And there, I think it's important that there be a certain measure of presidential control because that provides an important means of democratic accountability.
So I agree with everything that Naomi said. And let me just dig down a little deeper on this question because it is a live question and has been for over 30 years. But it seems to me that the case has been pretty well settled by all three branches of government over the decades. First, let me just say, in terms of why is it justified, I think it's justified because in our federal structure, Congress has delegated the authority to the agencies to fill in the details. That is their role. And there is, oftentimes with wide discretion, there is only one person in the executive branch who actually is connected to the people through the electoral process, and that is the president. And it seems completely logical, indeed important, that the one political official in this very important branch of government has a say over, within the band of discretion, what actions are going to be taken by his or her administrative state. If one held the view that the president could not be involved in the formulation of the most important policies that that the president's branch forms, which is through regulation, it seems to me the slippery slope is that the president has virtually no power over the entire branch. I don't know where the end point of that logic is. Now, why do I think this is a settled matter? Well, I think it's a settled matter because in each branch of government, Article 1, 2, and 3, has in essence spoken, implicitly or explicitly over the last 35 years, to endorse this concept. First, Congress could have intervened at any time and stated clearly by statute that the president could not exercise such authority. And they haven't. They have played around the edges with the Congressional Review Act and set up mechanisms that allow them to correct what they believe are incorrect decisions made by the executive. And also they can do so at any time through regular statutory process. Second, the courts have spoken through action or inaction. My father actually, with David Vladeck, brought one of the first cases against centralized review back in the Reagan administration. He lost. He has since become a convert to the value of the OHIRA centralized review process. Is a big fan. His son, having spent 6 years there and 2 administrations, had something to do with it. But I think he sees the value. But the point is, a legal challenge has not succeeded. And finally, presidents of both parties have endorsed and embraced and even expanded this. So you can't think of a more diverse set of executives than Ronald Reagan and George H.W. Bush and Bill Clinton and George W. Bush and Barack Obama and Donald Trump, okay? And that is 6 presidents who each in their own way have embraced this as good policy, good management. So I think in all three branches of government have, in a sense, endorsed the legality, constitutionally, and frankly, common sense of centralized review of regulation.
So within all of the executive orders, there's a very important qualification. And that is the review will take place to the extent permitted by law. And I'm going to ask Naomi, to the extent she can, talk about whether the recent executive order, which imposes a 2-for-1, hold the regulatory budget for the time being, but the 2-for-1, which imposes on agency a requirement to find 2 existing regulations and start to, if not completely eliminate, or at least modify substantially, those for every new regulation that the agency wants to issue, including regulations that are required, not just authorized, but required by law. Now, how do you see the to the extent provided by law meet, mesh, meld, surrender to the executive order's 2-for-1? And I do want to note that there is a pending lawsuit on this issue, and Naomi has done some academic work in the field, but may feel somewhat constrained in answering what's the best argument that this is still to the extent permitted by law.
Well, the President Trump's executive order on 2-for-1 includes that important language, right, in a number of places, right, that the actions taken have to be consistent with law or to the extent permitted by law. So that's very clear in the executive order. And I think one of the ways to think about how that fits with the existing statutory schemes in different areas that may require regulations is that regulations that are required by law, of course, have to go forward because that's the law, and the executive order has to be consistent with law. So required regulation will have to move forward. And the way we try to bring those two things together is to understand this executive order in a way that is flexible. And OHIRA and OMB have issued guidance, on how we interpret the executive order and how we're actually implementing it in practice. And we're not requiring agencies to, regulation by regulation, identify 2 things that they're eliminating in order to move forward with a regulation that might be required by law or, that is really important for a particular public need. We're looking at this like over the course of a fiscal year, right? So we do the accounting on this on an annual basis. So that relieves some of the pressure. I think another way that we sort of work these things together is we've allowed agencies to bank their regulatory and deregulatory actions. So for instance, if in a particular year they have eliminated a number of regulatory requirements and created a number of savings, they can roll that forward into the next year, to apply against new regulatory actions. Similarly, if they need to put forth a regulation that's going to be costly and they can't find the savings somewhere else, they can also roll forward a positive credit. So, or maybe the credits for that will be found from a different agency. So I think there's a lot of flexibility in the way that this is actually being implemented, and that flexibility allows for us to make sure that we are moving forward in a way that's consistent with the law.
Michael?
Before I ask or give you my thoughts, Naomi, just for my own edification and others, just to be clear, is it the current position of OHIRA that the two out rules, the two that must be eliminated, do not need to be identified in the rulemaking package for the new rule, that you're instead using a more aggregated year-end accounting, both in the reg budget sense and the 2-for-1 sense?
Yes, that's exactly
Okay.
right. So there doesn't have to be any kind of, there's no sort of specific matching up
Right.
of deregulatory and regulatory actions. We look at it holistically at the end of the year.
Okay, which is very shrewd for reasons that I will comment on in a moment. And so let me start with first of all, the commendation, the guidance that OHIRA put out was excellent, and I think clarified a lot of very serious questions that emanated from the original executive order. The second point I would make is that this is not an entirely novel idea in that other first world gold standard regulatory systems, including that in Canada, in the UK, and Netherlands, Australia, have all tried a variation on the 2-for-1. Some are 3-for-1, some are 1-for-1. There's different definitions of the costs that are covered. But this is something that has been tried and with some success in other countries. So we'll see how it works here. The reg budget is actually a little bit of a novel concept. Third, I would make the point that if ever there will be a test case as to whether retrospective review can actually work, this is it. So every administration has tried a variation on retrospective review over the years. They come in lots of different colors and designs. But this, I think, will be the test case as to whether over time you can really have substantial retro review. I have some personal views, and everything I'm saying is in my personal capacity, not GE. But I would say that I'll speak to the court case a little more than Naomi is able to. I think a facial challenge is challenging. We'll see what the judge determines. But because the executive order says that you cannot violate the law, this is, in essence, just a political document. We should all be clear about this, right? There is no police force at OHIRA. There is the power of the president to remove cabinet secretaries at will. But beyond that, it's purely a political exercise. So the agencies will be required to do what Congress has required them to do, and they won't be able to stand in the way. Similarly, if a court orders an agency to do something, they will have to proceed executive order. The court's not going to give a damn about the executive order. I think as applied, it might get a little stickier, because if I were an NGO, I would try to draw a nexus between the out rules and the in rules, which is why I think it's shrewd that the agency is going to do this in an aggregated sort of net cost basis over the whole year, because it's not a good reason under the APA to eliminate a rule because you have to pay for a new rule that you're proceeding with, right? So I think from a litigation standpoint, that could get a little sticky. And so at the end of the day, I have concerns about the lack of consideration of benefits and net benefits in many. It is called CBA as opposed to CA, and we can explore that. But I think legally, it's more likely than not that this will stand, because it really is family rules under the Trump administration within the band of discretion that the statutes and the courts provide you, the agencies, We want you to try to find costs to eliminate. We want you to pay attention to costs, never to violate your statutory mandates, but otherwise to do that. And I think that's why, frankly, you have elections.
And elections have consequences.
And elections have
If I could just
consequences.
say something in response to that. I think I appreciate those points, and in part because it is true. It is a kind of, the executive orders are a way of implementing the president's priorities to reduce regulatory burdens, and that's sort of the way that we're going about it. And you'll also see we're going to be announcing sort of the year-end accounting for all of this next week is when it's planned, and we're going to be substantially better than 2-for-1 and at substantially less than zero costs with respect to the regulatory budget. So I think that makes it also harder to kind of, it's not going to be like just barely 2-for-1. It's going to be a lot more than 2-for-1. And I would say that there are, in part, I think this is not so difficult to do right now because there are lots of rules that are ineffective or excessively burdensome or duplicative or inconsistent with other requirements. So I think we have a lot of material to work with on the deregulatory side at present, frankly.
Can I just add just a little bit of cayenne into the bouillabaisse here? So I agree with everything that Naomi said. What I do think is entirely appropriate and probably a discussion that should be had is whether or not that leads to good policy in the aggregate, okay? It can be legal and it can be a very effective management tool. I think we're sort of agreeing on that. But the question for the American people about whether over time it leads to better regulatory policy, it leads to net social benefits, et cetera, I think is a very, very fair question. And that's ultimately a political question, and I'm sure the administration will be very keen to engage in it. But I think it should be had. It's a little bit of a separate question, in my view, than from whether or not this is actually legal and an effective management tool.
Okay, so for now, we've been talking about review of executive branch agencies, regulations. All of the executive orders have applied exclusively to executive branch agencies, not those independent regulatory commissions, the multi-headed commissions where the president does not have the authority to fire at will the head of the agency. Now, that is a decision that was very clear with Reagan and was reviewed again for Clinton. And Michael, I'm going to turn to you on this one. Do you have any information as to how or why that decision was reached and whether that should be reviewed and with what consequence?
So just to be clear, the question of whether or not it is appropriate for there to be some form of White House review over independent agency rulemakings.
Yes.
Yes. Okay. So I think that the consensus, some might even argue the strong consensus of constitutional scholars who have looked at the issue is that under the unitary executive theory, the president does have the power and the authority to review regulations that emanate from independent agencies. Now, this question is trickier than the other questions we've spoken about before, because it seems in some tension with the idea of creating independent agencies. I will say, without getting into any specifics and naming names, that one of my evolving theories is that independent agencies aren't that independent and that they are very subject to capture by particular stakeholders for a whole variety of reasons. And for my $10, I'll take an EPA rulemaking any day of the week because everybody's in everybody's business during the course of that rulemaking. But I digress. Back to independent agencies. So I think the question becomes, A, is it legal, and B, prudentially, would it be helpful and a good thing? Legally, Cass Sunstein, other scholars have opined that it is within the president's authority. Why hasn't it happened before? I think it hasn't happened before, including under Republican administrations, because it's politically a tricky thing, right? The optics are tricky. There's a worry that the sort of committee barons in the Hill who oversee the various independent agencies are not going to be particularly happy with that exercise of executive authority. And so I think we'll see what President Trump does or does not do. President Obama walked up to the line in his executive order 13579 and strongly encouraged independent agencies to basically handle their reviews the same way non-independents do. The best solution, in my view, would be for Congress to speak on the subject, because it would eliminate any of the remaining, I think, political underbrush, okay, on an issue like this. And there are forms of executive oversight of independent agencies that are less hard, right? They're softer forms. You could imagine a non-binding review that is time-limited for very significant independent agency rules, where OHIRA would provide, say, a written set of comments where there's public transparency about whether or not the regulation meets the same criteria in 12866 as do the rules that come out of non-independent agencies. It seems to me, anytime you have beta testing, stress testing, more cooks in the kitchen on really important policy questions, you're able to identify and suss out and correct unintended consequences, conflicts, et cetera. It's a peer review, if you will. And I frankly think that in some ways independent agencies might find that they've got a little bit of an easier road through the DC Circuit and other courts for having the imprimatur of OMB review on their regulations. So I think it's an issue worthy of exploration. Presidents have been loath, I think mostly for political reasons, not to grab the authority that I think most agree they have. But I think its day may be coming. We'll see.
And there are several bills in Congress that speak to the sense of the Congress that the president could do this if he wanted to undertake this effort, which would lead me to ask Naomi, and Michael can chime in on this as well, does OHIRA really have the capacity to review the regulations, the proposed regulations of the independent regulatory commissions as well as the executive branch agencies? And does it have the expertise, particularly with respect to the financial regulations, which are the heart of many of the IRCs?
Well, I think, OHIRA is currently staffed at, it has been for some time, at kind of historically low levels, right? I think initially under Reagan it was around 90 people, and now we have about half of that. So, but I think that there is interest in Congress and in the administration in increasing the size of OHIRA, in part because of the importance of the regulatory reform agenda. So I think questions of capacity and expertise can be addressed through increased staffing. So I don't think that is too much of an impediment. But I also think, just to also highlight some of what Michael said as well. I think in some ways it's important to note that this idea of having a review over independent agencies is really become almost a mainstream view. It's endorsed by, I think, almost all of the former administrators of OHIRA, which I guess perhaps should not come as a surprise. But it's also been a long-standing view of the American Bar Association for over 20 years. They've been suggesting this. The Administrative Conference of the United States, which is also a nonpartisan body, has publicly supported OHIRA review. And I think it's because most people are persuaded of the legality of that and also some of the practical benefits of doing it, which I think are some of the same practical benefits of reviewing the regulatory actions of the other agencies.
Having testified in this area several times, it was true in the Reagan administration that they went to the Office of Legal Counsel at the Department of Justice and said, could we extend centralized review to the independent regulatory commissions? And they received an opinion that said yes. And then, as Michael said, they declined to do it. During the rewrite of the executive order for President Clinton, we too went to the Office of Legal Counsel at Justice and said, say, if we wanted to do this, would we be able to do so? They said yes, and we declined to do so. And it was all, as Michael was saying, I just want to underscore this, for political purposes. We're not going to put our finger in the eye of Congress, which is established and takes great pride in these independent regulatory commissions, and then say, well, we're going to review their work product. So if there were a sense of the Congress, whether it through a joint resolution or through actual legislation that the president would sign that says, if the president wants to do this, he may do so, I think would be consistent with the history. And we would see yet another expansion of executive power, which leads me to the other part of the title, the constraints. And I'm going to start simple with interest groups. Do either one of you believe that interest groups have been able to exercise any constraint or have any significant role to play in that regard? Michael?
You are an interest group, right?
Yeah.
So as an interest group, would you?
Yeah, and I'll answer that. Let me just finish one quick thought on independent agencies, because I think it's such an important topic. You asked about expertise, and I don't believe in any way that OHIRA can't develop and essentially hire the expertise that it needs to handle regulations coming out of financial regulators, because I don't think they are inherently any more complicated than sophisticated environmental regulations are, for instance, or sophisticated regulations dealing with healthcare. Regulation is sophisticated and technical, and it's another kind of technical sophistication for which you can find perfectly qualified people to serve as analysts. I do think that raises the question, though, in my view, if it were to happen, a condition precedent and necessary is that OHIRA is given sufficient and substantial resources to handle the reviews, because they will be substantial. It probably will add 30+% to the workload. And if those resources don't come, you essentially have diluted OHIRA's effectiveness across every agency, and that would be actually a step backwards. With respect to interest groups, I think it would be beyond naive to say that interest groups of all varieties don't play a role in constraining policymaking in general at the departments and agencies. So let's start there, because there's always this old saw against OHIRA that it's this political office. And I'll tell you, no office is more political than the OSEC of a department, okay? And I don't say that pejoratively or critically. That's fine. They have their stakeholders. They change by administration. There's a lot of voices that come into the agencies. But no one should be naive enough to think that as a regulatory policy, even a highly technical one, marches up through a department or agency to get sign-off at the highest level, that there aren't a huge number of political considerations, not just stakeholders, but what do key constituents in Congress feel about this, okay? I actually think that the OHIRA process is, to agree, less political than that. We used to, and when I was there with Cass, we would sit around and say, essentially, he would call it sewer talk, but there was sort of a mantra that we didn't really care what particular interest groups, and certainly what particular small groups of Congress people were necessarily saying about a rule to try to pressure us. We were trying to keep our eyes fixed on empirical questions, data, analytics, what the federal family was thinking about a regulation as we were going through it. So we really tried to firmly keep our gaze fixed on more objective considerations than political ones. I actually don't think political ones are bad. I think everybody plays politics. The government is supposed to be responsive to the citizens, and the citizens, have a voice in this. They have a First Amendment right to petition their government. So I think that's okay. I think different interest groups have varying levels of influence depending on who's in power, right? So I would say there's probably a different set of interest groups that have power in this administration than did in the last. There is also an impression of the OHIRA process that amongst many from my side of the spectrum, that the OHIRA process is dominated by business interests, and it's there chiefly to serve the needs of business. I can tell you a few things. One, business certainly doesn't feel like that, because I talk to the folks all the time, and off the record, and I genuinely don't believe that they have that sense. Second, I firmly believe that the career civil servants who staff OHIRA, many of whom were there when Sally was there and before, and have served every president since, believe that. They are there to do their jobs and to make better policy in their eyes. I do think that there are some empirical indicia that businesses engage in the process more often, more transactionally, right? And that rules that go through review tend to probably, on average, ratchet down a little bit. So I'll finish up by just posing the question, is that because of interest group influence, or is that because of the natural process of hardcore peer review and question asking that pulls you towards the center in any decision, any draft, anything you do? The reason businesses, I think, engage more than the NGOs, and the NGOs should be in there much more than they do, it's a subway ride away, is because regulatory costs are telescoped on a relatively few entities, and they have extra motivation to go in and plead their case, whereas social benefits are diffused across the millions. And I think there is less incentive for folks to get up off their duff and go in and say their piece. So that is why NGOs play such a critical role in aggregating those benefits in the voice of the people and getting into the process. And I wish they would more.
Naomi, you want to add anything to that on interest groups?
Sure. I think, interest groups, I mean, my experience so far as administrator, and I've only been in office about 4 months, although I admit
Time flies.
It feels like 20 months, right?
Yes, it feels like a very long time already. But I spend almost no time meeting with outside groups who are pressuring us. My staff take meetings under Executive Order 1286, which are all docketed, so there's a lot of transparency behind who they meet with on rules. They often try to meet with a wide range of groups. Like if one group is interested in coming in, they will seek out a range of perspectives and meet with them. So I think that that's all. I think that that's all fair and above board and part of the process. I would say I think one of the advantages of having centralized regulatory review, and I think one of the advantages of having presidential control, is that we do take, we aspire to, like Michael said, think about the American public, right? Like we're not beholden to any particular group, like maybe someone might be if they were representing a narrow constituency. We do have we have the nation as our constituency, and we're trying to implement regulatory policy that takes that into account. So I do think at least, in its best form, that's what regulatory policy should reflect through a centralized process of review.
I want to return to something that you actually mentioned in the very beginning, which is the role of Congress in establishing constraints on the regulatory process in the administrative state. And you mentioned that they can change the law if they don't like the way the agency is doing it. Are there other forms by which Congress can influence the regulatory process and has done so over the years that you would want to particularly identify, and how effective those may be? You want to start with that one, Naomi? Sure.
I think what we have seen is that Congress is often not willing to place too many restraints on the administrative process. They do so on occasion. There has been exercise of the CRA, right? This past year, we've seen that. That's been
Congressional Review Act.
Congressional Review Act. Overruling. Turning back regulations that were promulgated by the executive, and so I think that's been good. Congress can conduct oversight, right? They can question agencies about how they're implementing statutes and what types of policies they're putting forward. That can sometimes be effective. I do think also, and I've written about this in my academic capacity, I think there are also benefits that individual members of Congress can achieve by trying to influence regulatory policy, by helping their constituents or helping the particular interest groups that they work with. And I think that is often often an important benefit for individual members of Congress, but I think it can undermine Congress as an institution in terms of checking, what the executive is doing. But I do think it would be useful to see, more congressional constraints. I think particularly in the area of reducing some of the regulatory authority that agencies have.
Well, I think what we've seen also over the time is sporadic or occasional exercises of authority. For example, hold up, and if you're a senator, hold up the confirmation of an official at the agency until the agency either provides information on a subject or changes its mind on a particular subject. We've seen a lot of concessions being extracted for fear of very strong committee chairs who have not been reluctant to use their power. And then there is the budget and appropriations. Those are tools that are not used regularly or systematically, but nonetheless crop up from time to time. And I guess one of the questions is, do you think they're effective? Should there be a different way of thinking about this? Or do they actually work when they need to, and only when they need to?
I have a thought on that. So I think in the current environment, there's actually surprisingly little effective oversight. It's my personal view, okay, as is everything today, of the regulatory process. And that is in part because I think Congress is not acting in a particularly bipartisan way, because I think the most effective way to exercise control over the regulatory state is to come to an agreement of more than 60 senators, so both parties, that a law needs to be modernized, that a statement needs to be made by the Congress, okay, about a new direction or a paring back or a moving forward of regulatory policy. And I think we've gotten away in this country, sadly, from tackling important issues in the 21st century in a bipartisan way. And that is, that has limited the ability of Congress to exercise, I think, really meaningful, broad brush oversight. It's become very politicized and very ideological. Now, the CRA was used 12 times more this spring than it had ever been used before since 1996, when Sally and I were at the White House when it was signed into law. So that now has become a rejuvenated tool, time limited, at once every 8 years, basically, or 4 years, to exercise authority. Appropriations mechanisms, including riders, are, I think, minimally effective, but can be in a few instances. You can deny an agency the ability to spend any funds to develop, promulgate, implement, whatever word you want to use, and even enforce a regulation. So you can, in essence, gut the ability of an agency to engage in a particular regulatory action, but it has to be renewed each year. And so you have to go through this exercise each year, and it can become a bit of a sticky wicket in the passage of a piece of legislation, including budgetary legislation. So I think oftentimes ultimately gets expelled out of the process for larger reasons. In terms of letters, I'll just give you a quick note on the way we, I think, looked at congressional letters. If a letter was signed by multiple numbers of Congresspeople of both parties, that got our attention a lot more than a letter from 7 Republican Congresspeople when we were in office. Might be the same for them. When you see Congresspeople of both parties, including your own, telling you that they've got a big problem with a regulatory action, that can get your attention. So I think Congress clearly, at Article I branch of government, should be able to exercise, frankly, substantial authority over the regulatory state. I just don't think that it's particularly robust right now.
You mentioned Congress and legislation. there are multiple regulatory reform bills up there to change the process by which regulations are adopted, whether it be advance notices of proposed rulemaking or calling for evidentiary hearings in the middle of a rulemaking proceeding, or a topic we hopefully will get to, judicial review of the cost-benefit analysis, for example. Do you care to predict, either one of you, what the Congress will do in this, not this year, but this session, in terms of enacting legislation that would change the ground rules, i.e. amend the Administrative Procedure Act?
I can jump in.
I think it's always so hard to predict what may come out of Congress.
What a judicious statement.
But, there are a number of, I think, useful proposals, and I know that there are people giving a lot of serious consideration to them. So, maybe time for some regulatory reform legislation. I guess we'll see what happens.
As a battle-scarred veteran of regulatory reform battles in the Hill back to 1995 and the Dole and the Thompson-Levin bills, I predict that there will not be regulatory reform in this session. I may be wrong, but I have been predicting that for the last 20 years, and I've always been right up until now, at least since 1996 or 7. And the reason is it's highly, highly controversial. And you are amending a very, very fundamental statute, which, and as someone who operates with a company that itself operates in 180 countries around the world and deals with 180 regulatory systems, is still the gold standard in the world. The APA is still the gold standard for regulatory policymaking. And so that's a big step to modify the APA. You have to get past the filibuster in the Senate. And I think these reg reform bills always founder on the shoals of trying to get 60 votes. I've got a brilliant former colleague who's now at a trade in town who capsulized it this way. You have to have an 85-vote bill, not a 60-vote bill. Because as soon as you're going for 60 votes, you have to decide who are the last 3 Democrats, for instance, who are going to be the 58th, 59th, and 60th votes for a regulatory reform bill. That is a heavy or tall order. There aren't going to be the final 3 Democrats to vote for a 60-vote regulatory reform bill. Now, if you're talking an 85-vote regulatory reform bill, where you can get a lot of R's and a lot of D's around maybe a smaller idea that makes perfect sense, now you're talking. So if the strategy was to try to accumulate wins on 3 or 4 85-vote ideas over time, you aggregate those and you got something. So that would be my advice to folks. The action's going to be in her office, okay? So the question then becomes, what can you do from the executive branch side through executive order to accomplish a lot of the same goals as Congress is trying to accomplish through some of its more salutary ideas in legislation? And I won't put Naomi on the spot to ask her, but I would imagine that it will be an interesting situation to follow over the next few years as to whether some of these ideas are expressed through executive order in this administration.
So let me just turn very briefly and people who are thinking of questions, and I don't see where we're handing out the cards, but we may just take them from the floor. Do we have cards for questions? Yes, we do. So signal if you have a question you'd like written out, and then we will get those. But let's turn to the third branch of government, the courts and judicial review, and whether the courts are an effective constraint with respect to executive power, particularly in the rulemaking area. Thoughts on that?
Sure. Well, I think there's been a lot of interest in how courts can effectively constrain administrative action over, the past 10 or so years. And I think that's important because I do think the courts should provide important constraints on administrative action. They have, of course, a duty to say what the law is, and so then they have a duty to make sure that agencies are acting within the law. And so I think that's a very important role for the courts. And we see that there's interest in this not just amongst scholars who for a long time there's been kind of a cottage industry in writing about Chevron and our deference, but members of the Supreme Court have indicated skepticism about certain deference doctrines, and of course Congress has introduced a number of statutes that purport to in some way repeal Chevron, although I'm not sure exactly what that means. So I think that it's an important issue, and I do think that the courts need to be assertive about that.
Actually, one of the thoughts is to abolish Chevron and go back to Skidmore deference, where the courts give deference to the agency to the extent that it's warranted, which is a really easy thing to apply.
Yeah. And I think that's one of the points. It's kind of like everybody hates an activist judge when they're making decisions contrary to the way you think they should go. I think the left and the right both have their we hate activist judge memes. And I think the same goes with deference. I would imagine that this administration might welcome certain amounts of deference applied to substantial deregulatory actions that are coming down the line, which will be litigated, and they'll be litigated vigorously. So kind of depends. If you can fix Chevron to the extent it even needs fixing through legislation, I'm skeptical. I think it's a court-made doctrine, and I think the court should clean it up, and I think they are in their own way over time. I think they're tweaking and tightening and perhaps narrowing. But it's their doctrine, and I think it's up to that branch to fix it. I think courts properly exercise real limits or constraints on regulatory action. You see rules overturned in whole or in part. You see some judges exercising a harder look than others. That's the nature of the beast. But I don't think there's anyone at OHIRA or anyone in the agencies when they are promulgating a substantial and complex rule that isn't thinking hard during the course of that entire rulemaking about how they're going to defend it in court, whether they're going to have an adequate record, whether they're acting within the bounds of the delegated authority, the statutory authority that they have. And I think that check at the end is absolutely critical to force good policymaking.
One of the questions that has come is that you had mentioned the benefit side of cost-benefit analysis.
We're at minute 55.
At minute 55. And some have noted that the 2-for-1 executive order mentioned costs 17 times and benefits 0. So one of the questions is, how do you see the benefit side playing out? How does the administration weigh the benefits, both in new regulations that might be issued and in the candidates for the 2-for-1 that might be eliminated?
Well, of course, benefits are an important part of the calculation, and President Clinton and Sally's very fine Executive Order 12866 is still in effect. So deregulatory actions have to meet the same standards, which is when we deregulate, the benefits of the deregulation have to outweigh the costs of the deregulation. So we are still every day in what we're doing focused on both benefits and costs. Now, as we've talked about, it's a major presidential priority to reduce the overall regulatory burden, but we're doing that consistent with other longstanding principles of centralized regulatory review. And there are many rules where eliminating them or streamlining them or modifying them has substantial benefits for the public. And so those are the deregulatory actions that we're focused on.
So I do believe, because I have faith in OHIRA and the system, that the same benefits justify costs principle will be applied to new affirmative regulation and deregulation. And I trust, and it'll be interesting to see this played out in real time with real rulemakings, that the lost social benefits of a deregulatory action will be converted into costs, and the costs avoided by deregulation will be converted into social benefits, and that the benefits will continue to outweigh, which is what we usually mean when we say justify, or otherwise justify the costs. I guess my concern about the lack of benefits from the consideration of benefits from the overall policy is I wonder over time what impact that's going to have on the promulgation of socially beneficial new regulation. And I don't know the answer. We'll see. This is in some ways a grand experiment that's occurring. But it just still, there's something about the idea that not in the transactional sense, but in the overarching policy sense, we're sort of ignoring the benefit side of the equation and only focusing on raw costs that I feel is inconsistent with principles of benefit cost analysis, which is, I think, fundamentally a pretty conservative idea of policymaking and a really good one. So, you know, we'll see. But that I don't know exactly how that's going to play out, but it just seems over time like it could raise questions about whether we are foregoing regulations that are cost beneficial. They have net benefits and substantial net benefits because agencies and others are worried about that cost number, that big political number, which is, you know, it's a big deal number. It's going to be touted by this administration as an achievement. And it's something they set out to do, and they will rightly tout that they did what they said they were going to do. But the question is, are we missing opportunities to make the world in this country a better place? And we'll see. And I know you have a thought on that.
Yeah. Well, I think, this in some ways is I think a philosophical difference, right? Because, if the government, one perspective, and in some ways I think reflected in your remarks, is the government should try to affirmatively find ways to create social benefits through regulation. I guess that's one perspective. It was, reflected in the previous administration. But I think that there is a longstanding question that needs to be asked before that, which is there any need for government intervention in the first place? It's one of the criteria from President Clinton's executive order, right? Looking to see whether regulation is necessary. And then if it's necessary, is it lawful? And we apply cost-benefit analysis to make sure we're maximizing net benefits. But that first question, like whether this is something the government should be doing at all, is an extremely important one. And I guess it's not my view personally that the government should be acting whenever they can create social benefits. There's really a prior question about whether this is a space for government action in the first place.
So now it's getting fun right at the end. So I agree, and I am not advocating that government should sit around and gin up ways of creating social benefit and that that's their role. What I am suggesting, though, is that Congress has delegated authority to them in a host of areas to carry out certain mandates. Okay, this all starts with Congress. We need to remember that. And that when they regulate, they should follow the first maxim of 12866, which is there a market failure? And they should ask that question in a real way. And if there is, then they are not creating social benefit. They are internalizing externalities, which will otherwise not be internalized, okay, by government action. And so I guess I think you could do what Naomi's saying by saying, we are going to give a really hard look to affirmative regulations, and we are going to probe that agency till they scream about whether or not there's really been a market failure and about whether government action is necessary. And I don't think there's anything wrong with that. I think that might be a little different, we'll see over time, than having policies that ignore the entire benefit side of the equation in determining what your metrics are going to be for success for that year. That's a halvesies way of coming towards you.
Okay.
How's that?
That's fine. And I also think, you shouldn't be too worried, right? I mean, the entire administrative state is set up in a pro-regulatory agenda. So this grand experiment, as you characterize
I meant that
it,
as a compliment.
Yes,
by the way.
I know, is really pushing against quite a strong tide, right? Which is not necessarily going to easily abate. So maybe don't be too alarmed.
So I was going to ask another question, but I think we now have violent agreement among our panelists, at least at some level. And I would like to ask you all to show your appreciation for their work. Thank you very much.